Our next topic is Insider Trading 360. So enforcement trends, sweeps, key cases, and prosecutions. And this is a really great panel for this. Let's start with George Canellos to my immediate left. He's a partner at Milbank in New York. He previously served as co-director of the Enforcement Division of the SEC and also was an AUSA in the Southern District of New York, where he was chief of the Major Crimes Unit. Next to George is Steve Crimmins, a partner at Davis, Wright, and Tremaine in D.C. Steve previously served for 14 years at the SEC, where he co-managed the Enforcement Division's trial unit. Our moderator today is Carmen Lawrence. Carmen is a partner at King & Spalding in New York and former regional director of the SEC's Northeast Regional Office. Next down is Joseph Sansone, the current chief of the SEC's Market Abuse Unit. Relevant because, as most of you know, that's the unit that is, it uses data analysis to investigate complex insider trading rings and other abusive trading schemes and misconduct. So Joe is the man we want here today. Finally, at the far end of the stage, we have Bill Wright, a partner at Allen & Overy in its Washington, D.C. office. And Bill previously served for 8 years in the Enforcement Division as a staff attorney, a branch chief, and senior trial counsel. So Carmen, turn it over to you.
Thanks, Bruce. This year, as in past years, the SEC has brought just a steady flow of insider trading cases, and we look forward to sharing with you some of the notable cases as well as other legal developments. We decided to start with Joe because we know everyone wants to hear from the SEC, and we've asked him to provide an overview of the fiscal year-end results in the insider trading program. So we'll turn to you, Joe, to kick us off.
Thank you. And is my mic working? Can everybody hear me?
Yes.
Oh, there it is. So thanks. So before I get started, I want to offer the standard disclaimer that the views that I express here, although I am appearing as an SEC employee, that the views that I express are my own and are not necessarily those of the commissioner. So let me kind of dive in. I'll give you a little bit of a roadmap. I'm going to do a little bit of sort of retrospective in terms of some of the trends that we've seen over the past couple of years, and then a little bit of, I think, what lies ahead. And you know, these insider trading cases are, in some sense, looking back on them, is a little bit like a time capsule. You can see the things that were going on, and so a big part of that over the past few years has been COVID. And in the early part of the pandemic, the market was so hungry for information about the pandemic, but also about vaccines that were being developed, that provided an opportunity for insider trading. So probably the first case that I can think of involved a company called Vaxart that had obtained an agreement with another company to manufacture a drug candidate, not necessarily a successful vaccine, but a drug candidate. And that agreement and the fact that the company was moving toward developing this drug provided a stock bump, which one of the employees of that company that was going to help them manufacture this drug, he traded on that information, made $72,000, and that was a case that we brought based on some of the sort of early part of the pandemic in June of 2020. And then the next month, you saw Kodak, a company that has historically been associated with developing photographic film, secured a letter of interest from the government to make a $765 million loan to Kodak so that it could convert its chemical processing into chemicals that could be used in the manufacture of pharmaceuticals. And an employee, a consultant of a company that was involved in bringing that loan together, traded on that information, which drove the stock price up, and ended up, he and his cousin made about $1.5 million on that. So in the early part of the pandemic, I think you saw that, you know, information about combating the COVID crisis was really material to the markets, and unfortunately, people used that information to engage in insider trading. Toward the end of the pandemic, I think, we saw, what was probably more of sort of a conventional insider trading scheme when an employee of Pfizer, we allege, traded in advance of the announcement of a successful drug trial, a drug called Paxlovid, which was treated to treat COVID. And so in that case, we allege that this Pfizer employee made over $200,000 as well as tipping his friends. And so hopefully that is, from the COVID perspective, in the rearview mirror, and there are not going to be a lot of those types of announcements that we're dealing with. Similarly, in the area of SPACs that's been mentioned earlier today, we saw a number of cases involving trading around SPAC announcements. And I'm going to kind of assume, based on the group here today, that everybody knows what a SPAC is. But maybe one of the most interesting of these cases was a case that involved a SPAC called Digital World Acquisition Corporation, which in October of 2021 announced that it had reached an agreement to take public the Trump Media and Technology Group, social media platform associated with the former president, which sent the shares of the SPAC upward, and a member of the board of directors of that SPAC, two associates of his, traded, making in excess of $22 million on what we allege was illegal trading. There are other SPAC cases, but I'm not necessarily going to dwell on those. But so those, that's, I think, areas where we might not see that much more activity, or at least with respect to the COVID pandemic, hopefully not too much. But I think that some of the, features of the trading that we saw during the pandemic will probably continue because of telework. So one of the things, and it's actually funny because I was at this event 3 years ago, and it was remote, of course. And we were talking about, well, what are the things that we think might emerge as a result of telework in the pandemic? And a number of the people on the panel said there are going to be more opportunities for insider trading. And I think that that's exactly right. So we had these three cases that I can think of off the top of my head that all involved trading by the spouse or domestic partner, boyfriend, girlfriend, of somebody who had material non-public information. It's not necessarily a different type of insider trading, but I think that it just represents a different level of opportunity. So in the first case, a trader misappropriated information about an upcoming merger announcement based on information that he overheard from his domestic partner, who was working on that transaction on behalf of the company that she worked for. In the second case, the boyfriend of an employee, a law firm associate, misappropriated information from his girlfriend, again, to trade on mergers and acquisition information involving the acquisition of a company called Pandion. And in that case, the evidence showed that he was able to obtain a binder of documents that she had in the apartment that they shared. In a third case, an individual went so far as to access the computer of a domestic partner who worked at an investment bank and had information about upcoming deals that he, as well as a friend of his, traded on. He made $28,000. The friend made $730,000. So that's kind of a roundup of some of what we've seen. I think some of it, in terms of the announcement types, hopefully in the rearview mirror. But I think to the extent that telework continues, we're going to see some of the same activity in terms of misappropriation cases.
So, Bill, let me turn to you as general counsel of a law firm in possession of much MNPI. How do you manage the risk? You know, we've just heard from Joe about a lot of the telework cases and misappropriations by friends, relatives, spouses. So how do you manage that risk in terms of having, you know, information misappropriated from one of your lawyers, paralegal staff, et cetera?
It does make you need to change the training at the law firm, but also you should be thinking about it in advising corporate clients as well. I mean, the old training was don't insider trade. The penalties are significant. You will get caught. You'll go to jail. You'll be fired. Don't do this. And we still do that training, but I think now you've got to blend in more information security. What are you, you're working from home. You can't leave documents just out. I mean, you trust your family, you trust your significant others. That's great, but you still shouldn't, you've still got to focus on information security. So telephone calls, you got to think about where you take sensitive calls. Sometimes when there's, during the summer, we rent a house and there's a whole bunch of people. People make fun of me, but I do the calls in my car, outside, which is both, air conditioned and comfortable and, but also secure. And so you can say whatever that you need to say. And lock your laptop. And if you're just working from home, you might not think of those things. You might not think that your partner is going to misappropriate information, but these cases would suggest otherwise. And so the emphasis in training is on information security. It's on, for example, you end up at home, as sure everyone has over the pandemic, with a lot of material that's confidential client information. Some of it maybe is no longer sensitive, but maybe some of it is. You've got to get that back to the firm and shredded, and not just sitting around for anybody that's in your house to sort of rifle through. So these are some of the points that you make, in training. And you know, you also make when we're doing this, sort of a similar point. There's a case I was involved with a number of years ago where, an investment banker and his friend, who's a portfolio manager, had lunch. They were MBA classmates and good friends. Portfolio manager came back from the lunch, told everybody that his friend had just given him material non-public information, about an acquisition, and he put a whole bunch of trades on. The investment banker maintains he never said anything, and I had tended to believe him. There was no case here. Ultimately, there was an investigation, but, you know, if you work for one of the top investment banks, you can't really have an investigation like this. And so the person no longer works at the bank. And so it's significant even when you're talking to friends. You can't say, I've been in X place if X place is known for being the corporate headquarters for a particular company. And you've just got to think about information security as part of all this.
So, Joe, turning back to you, a couple of times this year, the SEC has announced coordinated insider trading actions along with the criminal authorities. They were packaged together, although not all of the civil cases had parallel criminal cases, but many did. In that respect, tell us about the factors that you consider in determining to refer a matter, refer a matter to the criminal authorities.
Right. So, I mean, I think a lot of the factors that we think about are very consistent with what we're doing in our own work. So we're looking at least in my unit, we're looking at trying to uncover complex schemes. These are schemes that, due to their complexity, often make for good referrals because the conduct is intentional. There's a high degree of scienter. And also, the people who are perpetrating these schemes are doing so through subterfuge. So having the benefit of a parallel criminal investigation that has additional investigative tools like search warrants can be a real game changer in terms of getting those cases across the finish line. We, of course, look at other factors, the repeat nature of the conduct, the size of the profits. But I think, something that is even more important than those things are looking at who the individuals involved in the scheme are. And I don't think we have time to discuss all of the cases, but focusing on cases that involve executives of public companies, focusing on cases that involve lawyers, accountants, members of the brokerage industry, including registered reps, as well as people who work at investment advisory firms. These are important cases for us because they kind of serve a double duty. If we can find the insider trading, we can root that out, but also it gives us an opportunity to eliminate people who are dishonest from those types of jobs that have that impact the securities industry, whether that be a CEO who is in charge of helping the company make adequate disclosures, or an investment advisor who's entrusted to manage individuals' finances.
Joe, can you give any guidance on when a case just gets too circumstantial from a litigation risk standpoint to bring it? Insider trading is kind of unique that way. You have so many cases that are built on circumstantial evidence. What makes it just a little too circumstantial to be comfortable?
Yeah, it's hard for me to say where the line is. That's, sometimes we do hypotheticals, and that can be fun. But I would say, I think sort of the term circumstantial case has gotten a little bit of a bad rap, in the sense that, it's sometimes people suggest that, because the evidence is circumstantial, that it's not enough. I think it really depends, on the strength of the circumstantial evidence. The reality is that there are so many ways for people to communicate now, that it's going to be hard for the government to secure evidence of exactly how the tip was communicated in an insider trading case. So I think that in a lot of cases, we're going to have to rely on circumstantial evidence.
We all remember the case a few years ago where the information that the ticker symbol was written on a napkin, which was then swallowed, or something like that. So there's
nothing surprises us, right?
So,
So, George, take yourself back to the Southern District. What factors would you have considered, in deciding whether to sort of accept the referral from Joe? I know it was way back, so.
Quality of the proof was probably number one, right? And there also needs to be a take the money and run quality that would give it jury appeal, and that would help you feel comfortable that you should bring the extraordinary authority of the criminal law to bear on the case. And so that meant it needed to involve significant quantities of money, some clarity of proof, and you need to be convinced the person was, a bad guy. To the extent that the case turned on some nuanced application of some of the more arcane elements of insider trading, like, was someone aware that there had been a personal benefit, for example? I think some of those cases that really turned on technicalities, you would feel were more appropriately resolved at the civil level, and you'd always feel a lot more comfortable declining cases knowing that the SEC was more aggressively pursuing those kinds of cases on the margin.
So a number of the litigation releases have been giving credit to the analysis and detection center within the market abuse unit. And we've heard some today about the importance of data analytics playing a role in almost every aspect of the SEC's various programs. And we're not looking for any secrets or anything like that, not that you would give them to us anyway. But can you tell us about the role that the center plays in the detection and investigation of the insider trading matters, and in particular, what types of tools are available to the staff?
Yeah, so I can't really talk about the sort of how the how the mousetrap is made. But I do think that it's useful to think about some of the cases that we've been able to bring in the past few years, and that really is because of data analytics. So one case that I think is particularly noteworthy is a front-running case that we brought at the end of 2022 that involved a trader in Oregon and his friend who worked at a large investment advisor, where the trader was trading in front of the trading flow by that investment advisor, and because that trading flow was so large, it was moving prices in a way that were predictable. The trader was able to consistently profit from trading ahead of those investment management trades, and made $47 million over the course of a few years. That is the type of case that really benefits from data analysis, because unlike a typical insider trading case, the material non-public information is not a mergers and acquisition announcement. It's not a quarterly earnings announcement. It's the trading flow of another firm. And so it's not something that's easy to look for. But if you can detect the pattern of suspicious trading, a suspiciously profitable trading, and then link that up with another factor, like the fact that it always precedes a trade by a large investment firm, then you've got a very strong pattern. And that is the type of case that we can get to the bottom of, and I think is also the type of case that would, to our conversation earlier, merit criminal interest, because of the fact that one of the individuals involved in the scheme works for an investment advisory firm. The amount of the profits are significant, and it's clearly intentional conduct. So that's a type of case. The hack to trade cases that we've worked on, I think, are another great example of this sort of pattern analysis that we've done. Last year, we were able to prosecute cases that we had brought in prior years, and the first matter, which involved hacking into a filing agent that was helping issuers make public filings like quarterly earnings, was prosecuted by the SEC as well as the District of Massachusetts, and they obtained a conviction in that matter against one of the traders, as well as a 9-year prison sentence. And in another matter that involved hacking into the Motley Fool stock picking service, another prosecutor was able to obtain a 28-month prison sentence against the person who engaged in that conduct. So these are, I think, great cases that would not exist except for these capabilities.
So I want to pivot to 10b5-1 plans, an affirmative defense to insider trading, if implemented, properly. We've all been aware that the SEC has expressed concerns around potential abuses of 10b5-1 plans, and there were recent amendments to Rule 10b5-1 effective earlier this year. So, Bill, I want to ask you if you could describe briefly the amendments and how you see them impacting insider trading investigations that involve 10b5-1 plans going forward.
Sure. And this panel talked about those amendments a bit last year. They weren't effective yet. They went effective in late February of this year. They've imposed a number of requirements. And I'm going to talk in a minute about a case that exists from the other world being the pre-effective date of the amendments. And there still probably will be cases that relate to the plans that were entered into amendment. And so, and there's one from March this year we're going to talk about. But the key things I think that the amendments do, they create a cooling off period. So for officers and directors, it's the latter of 90 days after the plan's entered, or 2 days after the K or the Q is filed, which is in effect an effort to sort of slow everything down. Certifications that that officer director would need to make, that they don't have MNPI, which makes sense, but also that they're not using this plan to evade 10b-5 liability or doing it for some purpose like that. The amendments also eliminate sort of overlapping plans. That was a common issue and a common thing when I've advised financial institutions that have plans, and then someone comes in with plan number 3 or 4, and they're wondering what they're supposed to do. So that is effectively eliminated, and also it limits sort of single trade plans to once in a 12-month period. So it does clamp down pretty significantly. It also requires the transactions to promptly be identified in a Form 4 or 5, checking a box that it was subject to a 10b5-1 plan, and the date that the 10b5-1 plan was entered into, and so all that information is there. And there's some other things on the issuers themselves, including disclosure of their policies and procedures related to insider trading and 10b5-1 plans. You wonder, why was that potentially necessary? And one thing to point to is a case that was brought in March, so right after the amendments went effective, but it relates to prior conduct. The Pizer case, which there was a chairman of a public company who learned information. The commission alleges learned information that their biggest customer, 50% of their revenue, they had significant issues with on a going forward basis. The chairman entered into a plan. Interestingly enough, went to the first firm. The first brokerage firm had a requirement of a cooling off period, so he didn't use that firm, went to a firm that didn't have such a requirement, and entered into the plan. A few months later, when there's pretty significant evidence listed in the complaint that the chairman knew precisely that the client was the customer, which was 50% of the revenue, was going to walk imminently, entered into a second 10b5-1 plan. And this is interesting, and it sort of warms the heart of a former enforcement and trial unit person. The brokerage firm suggested a 30-day cooling off period, saying that was sort of best practice. And the response from the chairman was, "It won't work." Which is not the best thing he probably could have said. And so the commission brought this case. It's under the old plan. Unfortunately, the amendments didn't save him as they would if the conduct occurred later, because the cooling off period is mandatory. There's no overlapping plans, and I think it would have been tougher for him to do it. The issue is, what do you do now, right? What are things should people be focused on? I mean, one is making sure that issuers' policies and procedures are really up to date with the amendments, that people understand how they work. I mean, I'm familiar with a situation where an executive asked that a document be dated at a time earlier, the plan be dated at a time earlier, to sort of, in effect, get around these new cooling off requirements. The company didn't do it. There were reasons why the person thought it would be okay. None of them particularly great, but the company didn't do it. But that's the kind of thing you've got to worry about, and you've got to make sure your plans, policies and procedures are solid. The other thing to keep an eye on is trading by executives outside of the plan. I think we've seen a little bit of that. I think there may be more of it, since they can't use the plan perhaps the way that they had used it before. And I think companies really need to focus on their insider trading policies and procedures and making sure that it's dealing with that properly on a going forward basis.
Thank you. So there were two Court of Appeal cases that were decided this year that I think are worth spending a little bit of time talking about. The first was out of the Second Circuit. US v. Blazak, I'm sure I'm mispronouncing that, as well as the SEC versus Clark case out of the Fourth Circuit. So, George, would you discuss those two decisions and the impact that they may have on future insider trading cases?
Sure. Can I throw a Supreme Court case in too, Simonelli, which I think has a lot of implications? All right. So I guess it's been 62 years, I think, since like the beginning of the development of insider trading law, if you count Katie Roberts as the first case. And it's almost comical how much disagreement there is among the courts on the scope of liability. All the recent cases out of the Second Circuit have been split decisions of panels, and all the most recent ones have two decisions. So there's Martoma 1, and there's Martoma 2, and then there's Blazek 1 and Blazek 2. And so in December, Blazek 2 was decided, and it is a super interesting case. What you kind of see if you're following the case law development and the arc of enforcement policy and practices is that several years ago along came the Newman case that said basically personal benefit is a meaningful bar. It requires a meaningfully close personal relationship between tipper and tippee, or else you don't meet the standard, at least under Title 15. And with that standard now having been erected by the Second Circuit, presenting a significant obstacle to prosecution under Title 15, a number of prosecutors' offices, especially the Southern District of New York, began to aggressively push for Title 18 to be used as a tool for insider trading. And Title 18, the use of Title 18 kind of, let's say, reached its highest point in the Blazek case. Now, as a result of some recent developments, I think everyone's going home to Title 15. If you are a prosecutor, you'll be going home to Title 15, and you will be no longer playing in the neighborhood of Title 18. But what happened in Blazek is Title 15 and Title 18 charges were included. The district court instructed the jury, consistent with Newman, that you needed to have a meaningfully close personal relationship for Title 15 charges, omitted that element for Title 18, and the jury acquitted on all the Title 15 charges and convicted on the Title 18 charges. That case involved an insider trading charge against an employee of the Center for Medicare and Medicaid Services, a former employee of CMS who had become a political consultant, and two of the clients of the political consulting firm who had traded on information about a change in reimbursement policy that the CMS employee knew about and disclosed to his former colleague, now working as a political consultant, amidst schmoozy lunches from time to time with pretty much minimal personal benefit, maybe some career advice, the kind of stuff that used to fly before Newman as qualifying as personal benefit. They all were convicted on Title 18 and acquitted on Title 15. I'll just add a footnote. In the intervening time between, the decisions in Blazek and the instruction in Blazek, Martoma 2 was decided, which essentially wholly eliminated the high bar that had been created by the Newman case, creating great consternation and dissents within the Second Circuit, saying Martoma was improperly abrogating another Second Circuit precedent without the appropriate imprimatur of Supreme Court change of law. So probably there would have been a completely different instruction in Blazek today, and probably there would have been a different result under Title 15. Anyway, we're on the topic of Title 18. So what then happens after Blazek's conviction is that there's Blazek 1, in which the convictions were upheld. Blazek valiantly argued that the personal benefit test should be imported into Title 18. The Second Circuit rejected that. And then the case, they were nothing left to do but a cert appeal. The defendants applied for certiorari, and there was an intervening decision in U.S. versus Kelly, which is the Bridgegate case in New Jersey, where there was a criminal case brought for mail-in wire fraud against associates of former Governor Chris Christie of New Jersey for shutting down 2 of the lanes of the George Washington Bridge. And it went to the Supreme Court, and the Supreme Court said, mail-in wire fraud, just like Title 18 securities fraud, requires, as the object of the fraud, money and property. We just don't see how having political payback of closing down lanes has a money or property object. We just don't see it. We see that as distorting the regulatory function of the sovereign, sure, but not money or property. And so those convictions were reversed. At this point, something very weird happens, which is the Solicitor General takes that case, which bears very little resemblance to Blazek, confesses error in the Blazek case, and consents to a remand of the cert petition to the Second Circuit, and then expresses a Justice Department view, post-Kelly view, to the Second Circuit, in which the DOJ says that post-Kelly, we think that information to be property needs to have value in the hands of the party from which the information was stolen, which severely compromises the ability of the government to bring cases for misappropriation of government information, since since very often information that's highly valuable and resides within the government, like important decisions about new CMS billing rates, really have no value to the government. It's not property in the hands of the government. The Second Circuit then, in a split decision with a vehement dissent from Judge Sullivan, agrees with the government's position in a case that has a little bit of uncertain precedent, because it first talks a lot about how the executive branch has enormous authority to exercise prosecutorial discretion even after the fact in nollying cases and the like, but nevertheless says the court still needs to at least marginally consider the issue, and then agreed with the government. So that ruling essentially says that 2 things that are of importance and significance for future cases. One is the information needs to have value in the hands of the party from whom the information was misappropriated. As the dissent points out, that seems inconsistent with just a lot of case law where public companies may have information that they could in any way benefit from themselves under the law, and yet we have many, many precedents in that area. But it calls into question some of those precedents. And second, it does draw a significant distinction between information in the private sector and information in the possession of the government, and suggests that there'll be pretty bright line distinctions between the way the courts might analyze very similar fact patterns. So that's something. That case is of significance with many interesting implications. I'm going to add one more, which is there's a case called U.S. versus Simonelli that was decided in the Supreme Court, and it's very hard to overestimate the significance of that case for application of fraud doctrine under Title 18. Since the early 90s, there have been numerous prosecutions upheld by the Second Circuit under what was the Second Circuit called the right to control theory. And the right to control theory was one in which essentially the courts and the juries said, we're not going to really decide whether a victim was harmed. We're not going to decide whether, let me take an example. If I told you I'm going to use, if you're giving me some information and I told you I'm going to use it in a particular way, and then I don't, and you're really unhappy and you think maybe you were prejudiced, and I think you weren't prejudiced, that I didn't harm you at all, the courts say we don't debate that. If, George, you deprived someone of information that was relevant for them to make a commercial decision, we think that's a form of fraud. And you don't get to say you didn't intend to harm them after the fact, or you didn't really gain any benefit, or they would have been better off afterwards. That's the kind of stuff Ponzi schemers say all the time. Didn't intend to take anything from you. You can't say that. That was law of the Second Circuit, bedrock law. And in a 9-0 decision authored by Justice Thomas, the Supreme Court just said that that's never been the law, should never have been the law, and importantly also criticizes the idea that it says by treating mere information as property, there's almost no limit to the Second Circuit's at the application of this Second Circuit doctrine. And if you read the quotes in there, and you're a defense lawyer, you're going to want to take them on the road immediately to insider trading doctrine and import them into all your briefs.
Yeah, so I read the case, very interesting, very significant. I'm going to spend our last few minutes talking about crypto in the insider trading space. We've heard a lot about crypto today, and you're going to hear a little bit more about crypto now. So Steve, tell us what we need to know.
Crypto is the next new thing in securities reg, and in the most dynamic area of securities reg, which is insider trading. It's no exception at all. We have two cases to talk about. One involves a cryptocurrency, one involves non-fungible token, NFT. The crypto case, you heard a little bit about last year, was Wahi. Interesting case. SEC brought one as a securities fraud case only under Title 15. Justice Department brought another one only under Title 18 as wire fraud. Either way, they figured they had it nailed. We thought we'd get some real guidance out of that. Disappointment, we didn't. It got resolved. The resolution was kind of weird. We had guilty pleas. First, it was a guy who worked for, how do you trade in crypto? Basically, it's the big event is the listing on a centralized exchange. That pumps up the price. Previously, it might have been traded on maybe a smaller centralized exchange, more likely than not in a decentralized exchange, which is anonymous trading, non-custodial, so it's really kind of, but it's recorded on the blockchain, so you can figure it out. So in any event, they pled in the criminal case, the Title 18 stuff, and literally the day after the plea was entered by the second defendant, they moved to dismiss the SEC civil case. It's not a security. Okay, you got us under Title 18, as George was talking about a minute ago, but we can still litigate that. But then they ran up the white flag and settled with the commission, so we don't really know the answer on that. This was an individual who worked for a centralized exchange, Coinbase, who was alleged to have tipped his brother and a friend. So that's how that went down. Interestingly, we got a study from an outfit I had not heard of before but apparently is a big deal, called Solidus Labs, which does research on blockchain type stuff. They can actually trace a lot of stuff, detective work, with a DEX-based tool, which they make available to regulators, and I'm sure the SEC's got its own that's a lot better, but in any event, they came out with this amazing statistic a couple of months ago that of all listings on centralized exchanges of crypto, over 56% bear hallmarks of insider trading. So there's a lot of, if this is insider trading, if these are securities, there's a lot of it going on. So the commission has this one case out there, Wahi, a settled case. What's going to happen? Well, we also heard a little bit earlier that in July we got dueling Southern District decisions. Judge Torres said it can't even be a security if it's exchange traded. And 2 weeks later, Judge Rakoff in the Terraform case said, I read Judge Torres' opinion. I disagree with it. And I think it can be. The product is the product. That's not how it's sold. So who knows? We had to work our way through all this stuff about that George was talking about, that we had the big wars on personal benefit over the last few years, and all the stuff before that, back over 62 years or however long it's been. Now we have to figure out a more fundamental question. Is it a security? So trading a material non-public information in breach of a duty to the issuer or the source of the information, maybe it's a derived duty, all that other good stuff. But is it also is it even a security? So that's where we are on the cutting edge of crypto. And I see we're out of time, but there is also the world of non-fungible tokens. There's one on that too. U.S. v. Chastain, Justice Department only did a criminal case. And they figured, the SEC is not going to do NFTs and insider trading. Maybe they won't, maybe they'll stand back entirely. But a couple of weeks ago, they came out with a couple of offering cases, 2 offering cases, where they said, NFTs can be securities too. So will we see insider trading cases brought on this? Will the commission wait until after it's settled down whether crypto is or isn't a security before they launch insider trading cases or not? We don't know. But that's to talk about next year.
Okay, terrific. Thank you so much. Appreciate it.